Hello everyone, this is the first video on the topic of child arrangement order. This is also commonly known as a child contact order or section 8 order. I will explain in this video the legal position of the parent who wants to apply for a child arrangement order or the contact order. I will also explain the position of the parent suffering from domestic violence within the context of the child arrangement order. Let's move to our topic. The breakdown of the relationship invites the parents to decide the arrangements for their children. For example, who will they live with? How much time will they spend with their parent individually, and what arrangement would be in choosing their schools, taking them on holidays, and accessing their medical information. So one important point to note is that this is always in the best interest of the children to allow them to thrive under the care of both parents, unless the existence of one of the parents in the child's life is harmful to the child. It is always an important point to consider that the child shall not be used as an instrument to settle personal issues between a couple. For example, if a couple split up on unfriendly terms, this shall not be the only or sole cause to disallow one parent to be prevented from contacting the child. So let's move to our topic. Where parties cannot agree on which parents the child should live with post separation, one of them can apply for a child arrangement order. This is also, as I explained, called Section 8 order because it falls within the Section 8 of the Children Act 1989. A party can apply for different types of orders according to their situation. So this includes the first, live with order. For example, which parent the child shall live with. The court may grant a live with order to one parent only or to the both parents. This is very important to note that where there is the order stating that the child is to live with one or more parties, Section 13(1)(b) of the Children Act 1989 get involves. It makes it clear that no person may remove a child from the UK without either the written consent of every person with parental responsibility or leave of the court. An exception to this is set out in Section 13, subsection 2 of Children Act 1989, which states that a person named in a child arrangement order as a person with whom the child lives may remove the child from the UK for a period of less than 1 month without the consent of the other parent or the party having the parental responsibility. It is again important to note this exception enables a parent with the live with order in respect of a child to take the child to holiday for up to 1 month without the consent of the other parent. If, however, that parent takes the child out of the UK for more than 1 month, this will constitute a criminal offence under the Child Abduction Act 1984. This is explained under Section 1, subsection 1 of this Act. So this was the live with order. The second type of order a party may seek is to spend time with, or the other word, the contact. For example, have contact with the other parent. Once the live with order is decided, the important issues that needs to be settled is how much time the child shall spend with the other parent. This includes regular contact, for example, weekend contact or weekly or weekday contact, and holidays contact. The party may seek an order to specify how long the parent having contact can take the child on holiday and whether that holiday can be overseas. This is again important point to note that the court starting point is that a child will benefit from having contact with both parents, even where there are allegations of domestic abuse. This does not necessarily means the court will not allow contact. However, these cases need to be considered carefully. The Court of Appeal has held that in the cases involving domestic abuse, the court should consider the past and present conduct of both parties, the effect on the child and the residential parent, and the motivation of the parents seeking contact when deciding whether contact is in the child's best interest. So the court will consider those points where the application is filed with the court and one of the party claimed the domestic violence. Where there are allegations of domestic abuse, there is further guidance is given in Practice Direction 12J of Family Procedure Rules, which is publicly available online. This states that domestic abuse is harmful to children, whether they have been subjected to domestic abuse or whether they live in a home in which domestic abuse has been perpetrated. Even if the child is too young to be conscious of the behavior, the practice direction provides detailed guidelines that the court must follow in these cases to promote the safety and well-being of the child and makes provision of the proper administration and determination of the facts of any abuse within the context of child arrangement order proceeding. When deciding the issue of child arrangements, the court should ensure that any order for contact will not expose the child to an unmanageable risk of harm and will be in the best interest of the child. This is also explained in paragraph 35 of Practice Direction 12J. The court might decide, for example, that contact should be supervised either by a social worker, family member, or at a contact center. So you need to know that the contact centers facilitate and support contact or handovers in cases where there are issues which make it difficult or unsafe for this to happen at one of the parties' home. So in addition to the child arrangement order, which I just explained, a parent can also apply for other order if he or she feels it is required. This include the first type of those orders as specific issue order. For example, if the parent cannot agree on where the child is to go to school, what religion the child should be brought up in, or whether the child should receive medical treatment, one party can apply for a specific issue order. This is apart from the child arrangement order we discussed earlier. The second type of the interim issue or the order you can apply is a prohibited step order. This prevents a party from taking a particular step in relation to a child. They are used to deal with single issue disputes. The sorts of issues to which these applications might relate are very similar to the issue to which a specific issue order might relate. For example, if one party with parental responsibility is informally allowing the child to be known by a new surname, this concludes the first part of the child arrangement order. In the second part, I will take you through the important factors that the court will consider in making such orders. For example, which factors the court would consider when such application is filed with the court. I hope you enjoyed watching my video. This video is made for educational purpose only. If you require legal advice related to your circumstances, please see your solicitor. Thank you for watching my video.